Yeah, welcome back, sir. In the last class, we have completed first topic of the SOGA. We'll revise that rapid revision. The SOGA weightage will be around 21 marks. How many marks? In the CA Foundation final exam. So first, what is the history of the SOGA? Actually, SOGA is not a separate act. Once upon a time, it is part of the Indian Contract Act. Section 76 to 123 of the Indian Contract Act repealed, removed, separated. They formed a new act called Sales of Goods Act on 1st July 1930. However, on 1st July 1930, they're forming an act called Indian Sales of Goods Act. Indian from 22nd September 1963, the word India is removed. Now it is called as only Sales of Goods Act. So, what is the moral of the story? Once upon a time, SOGA is part of the Indian Contract Act. Section 76 to 123 of the Indian Contract Act separated. They're keeping its name as the Indian Sales of Goods Act. From 22nd September 1963, the word India also removed. Now it is only SOGA. This act is applicable to whole of India, including Jammu and Kashmir. Scope. This act deals only with the sale, only with the goods. This act will not deal with the mortgage and pledge. Mortgage is still dealt in the Transfer of Immovable Property Act. Pledge is dealt in the Indian Contract Act. Applicability of the Indian Contract Act. So we will apply the Indian Contract Act to SOGA also. Whenever the provisions of the Sales of Goods Act are silent, the provisions of the Indian Contract Act will be applicable. For example, Section 4 of the Indian Contract Section 4 of the Sales of Goods Act explains to enter into contract of sale there must be goods. There must be goods. Which kind of the goods? Act is silent. So Indian Contract Act explains the goods must be lawful goods. SOGA explains to enter into contract of sale there must be buyer and seller. How the buyer and seller are supposed to be? SOGA is silent. Then Indian Contract Act said to enter into contract of sale buyer and seller should be major, sound mind and not disqualified by law. Done. So whenever the provisions of the SOGA is silent, then provisions of the Indian Contract Act will be applicable. Next, this one is very important. Contract of sale. Section 4. He is asking in the exam better star, 5-star. So in the exam, he will ask different contract of sale and it's essential. So contract of sale is a contract whereby seller transfers or agrees to transfer property in the goods to the buyer. For the contract of sale is a generic term. Generic means general term. Contract of sale includes both sale and also the agreement to sell. These two are included in the contract of sale. So what is this definition? But let us make the analysis. Contract of sale is a sale of good is it's a contract only. It must satisfy section 10. There must be seller, there must be buyer, there must be transfer of property, and there must be price also. We'll analyze the definition better. About definition, we'll analyze. First one, to enter into contract of sale of the good, there must be buyer and seller. There must be minimum of two persons. One is buyer, other one is the seller. Who is the buyer? Defined by section 2. 1. Buyer is a person who buys or agrees to buy the goods. Satvika said, Srinath sir, will you sell this remote to me? I said, yes, 100 rupees. She is giving 100, I am giving remote. It's a sale. It's a and Satvika said, sir, I like your bike. Can I purchase? I said, yes, 1 lakh. But Satvika said, I will use the bike for 10 days. How many days? 10 days. After using 10 days, if I feel the bike is comfortable, if mileage is more than 40, I will take the bike. I said, okay. It will become sale on 10th day. I said, no, sir, if the mileage is more than the 40. So she is agreeing to buy, I am agreeing to sell on 10th day. So, in the same way, seller is a person who sells and agrees to sell the goods as per section 213. And there must be goods. Goods means every kind of movable property. It should be movable. It should be, if it is immovable, it is not a good. Every kind of movable property other than legal tender and actionable claim. Legal tender means currency in circulation, paisal. Yes or no, sir? You have 1000, you have 500 rupees note, 100 rupees note. That is legal tender. A tender? So goods means every kind of movable property excluding currency. Currency is movable, but it is not a good. With currency, we purchase the goods and every kind of movable property other than the actionable claim. Actionable claim is a claim which is enforceable through court of law, like promissory note, like bills of exchange, like check. Promissory note is movable, yes or no, sir, but it is not a good as per SOGA. Actionable claim is a claim which is enforceable through court of law. Example, promissory note. So goods means every kind of movable property other than actionable claims and legal tender. Goods include shares, stock, patents, copyrights, goodwill, water, gas, electricity, standing trees, and growing crops also. If they are separable, right now one tree is there in the field, that is not a good. If separating from the earth, it will become good. Plantations are there, growing grass is there, it is not a good. If separating, it is a good. So goods includes shares, stocks, है ना, patent rights, copyrights, goodwill, water, gas, electricity, standing trees, and growing crops. If they are severable otherwise. And there must be transfer of property. And property is two types: general property and special property. General property means ownership. Special property means possession. For example, this remote belongs to this academy. They have the general property ownership. Right now, I am holding this. It's a special property. If nothing is mentioned, we have to assume property means general property only. In case of sale, ownership will transfer immediately. Property means ownership. Property means in case of sale, ownership will transfer immediately. In case of agreement to sell, it will transfer in the future date, subject to fulfillment of condition. In our example, mileage must be more than the 40. And there must be price. Price is the monetary consideration for the contract of sale of the good. Yes or no, sir? Which consideration? So, I am giving the pen to Satvika. Satvika is giving me 10 rupees. The 10 rupees is the price. And if there is only exchanging of the goods, it is not a price. I give the pen to Satvika. Satvika give me pencil. It is a barter, but not the contract of sale. It is not a price. And if there is no consideration at all, I give the pen to Satvika. Satvika said, "Thank you, sir. It's a gift. It's a." However, consideration can be partly in money, partly in kind also. So I give pen worth of 10 rupees. She gave me 5 rupees coin and pencil worth of 5 rupees. But my pen value 10 rupees. It can be partly in cash, partly in the goods also. And every contract of sale must satisfy section 10. So this is the definition and it's essential, very, very important from exam point of view. Next, formalities of the contract of sale, section 5. Formalities of the contract of sale. What are the formalities? So to enter into contract of sale, there must be offer, there must be acceptance. Offer by one party, acceptance by another party. Contract of sale may be expressed or it may be implied. If it is expressed, words may be spoken or words may be written. And delivery and payment. In SOGA, 3 things will be there. One is payment of the price, delivery of the goods, other one is the property or ownership. Ownership is important. These two are secondary. Price may be postponed, delivery may be postponed. If ownership is transferred, it is a sale. Done? So, delivery may be immediate, payment may be immediate. Delivery may be immediate, payment may be in installments. And 5,000, 5,000, 5,000. And delivery may be immediate, payment may be in the future. Delivery may be installment, 5 bags plus 5 bags. Payment may be immediate to installment or in the future. Any combination can happen. But what is more important? Don't bother about delivery and payment. It's secondary. And delivery may be in the tomorrow, next day. But payment may be immediate to or installment to or in the future. Done. So first priority should be given to ownership. Done. Next one is the direct question he may ask in the exam beta. BBIMP, I kept already 5 stars. How many stars? Sale versus agreement to sell. Sale versus agreement to sell. Sale is the executed contract. Everything is ho gaya. I give the pen, you give me pencil. Sir, I give the pen, you give me money. Executed. It's a executory contract. Tomorrow I have to give the pen. Tomorrow you have to give the money. And in case of sale, ownership will transfer immediately. In case of agreement to sell, ownership will transfer in the future time. It will create just in REM. Just in REM means right on the thing. I purchase this remote. I become the owner of this remote against the whole world. No one can claim this remote as their remote, including Casio also. Manufacturer also. I purchased. It will create just in REM. It will create just in persona. So Satvika said, if mileage is more than 40, I will take the bike. Mileage is 50, still she is not taking. Can I file a case on her? Yes. For damages. For I have right only on Satvika, but not on her husband, but not on her mother or father or children. Yes or no, sir? She is having 4 children. Hai na? Types of the goods. How many goods? So the goods generally will be existing goods. Which goods? Existing and specific goods. Generally, goods will be future and contingent goods. Goods will be manufactured. And risk of the loss. If the ownership is transferred, no, beta, even the position is with seller. Who should bear the risk of loss of the good? Sale, no. Goods is with me. Goods destroyed. Who should bear the risk of loss of the goods? Seller or buyer? Buyer. Ownership is transferred. So buyer has to bear the risk of loss of the good. Here, goods are given to buyer, but ownership is with me. Who should bear the risk of loss of the good? Seller. Simple. Whoever is having the ownership, they'll have the risk also. I'm having the ownership, I will have the risk. If she is having the ownership, she will have the risk. Leave about the price, leave about the position, leave about the delivery. Then next is buyer's breach. Whose breach, beta? If buyer makes a breach, ownership is transferred. Ownership is transferred, but position is not given. Can I file a case on the price? Yes. Ownership is given. I can ask for the price. Even the goods are position of the seller. Delivery is not important. Yes or no, sir? Ownership is transferred, so you have to make the price. Even the goods are with me. You can take the goods at your own time. Then whenever you have a time, you can come and take the goods. But ownership is transferred. I have the right to file a case on you for the price. For them, if the ownership is not transferred, I can't file a case on you for the price because ownership is not transferred. I can sue only for the damages if you make the breach. Ramcharan. Next, seller's breach. Whose breach? Seller. If seller is unable to do delivery of the goods after transfer the ownership, can I file a case on for taking the delivery? Yes, because I have the ownership, I have a right to enjoy the position. But in case of the agreement to sell, if seller is making the breach, if he is unable to do the delivery of the goods, we can't file a case for the goods. We can file a case only for the damages. If the buyer become insolvent, who become insolvent? Buyer become insolvent. So the official receiver can recover the goods from the seller, and seller can recover only proportionate amount. उसको बोलते हैं rateable dividend. Which dividend? Rateable dividend means proportionate amount. Here, in case of the agreement to sell, if buyer become insolvent, who become insolvent? Seller need not sell the goods to official receiver of the buyer because ownership is not transferred. Last, if seller become insolvent, who become insolvent? Seller. Buyer can recover the goods from the official receiver of the seller because I have the ownership. I can recover the goods. Then, and in case of agreement to sell, we cannot recover the goods until full payment is made because ownership is not yet transfer. Clear? Next one we discussed is the main important concept of is asking the exam BB IMP already 8 question 8 marks 7 marks sorry. Sale versus a hire purchase agreement. Sale versus a hire purchase agreement. Hire means rent. Hire means if you go to main road behind the auto for hire will be there. You can use this auto for 1 kilometer pay 20. You can use this auto for 2 kilometers you can pay 40. We will give this auto on the rental basis. Which basis? So sale is governed by Sales of Goods Act. Hire purchase is governed by the Hire Purchase Act. So next, contract of sale is a contract of sale. Hire purchase is a agreement to sell. It may become sale on the payment of last installment. So here, goods is delivered. Goods need not be delivered immediately. Delivery can be postponed. But hire purchase goods must be delivered immediately. Ownership will be transferred immediately. Ownership will be transferred on payment of last installment. And here, buyer has no right to terminate. It's like a marriage. Here, buyer can terminate at any point of time. Yes or no, sir? Hirer can terminate. In case of the buyer's breach, if buyer is unable to pay the price subsequently, we will not recover the goods. We will file a case only for the price. Here, we will take back the goods. Whatever he has paid treated as the hire charge, rent for the last 3-4 months. Here, we can transfer the good title to third party. I am the owner. I can give the ownership to someone else. Here, I don't have ownership. I can't give good title to someone else. It need not be in writing. It can be oral. It can be writing. It must be in writing. There is no benefit of there is a benefit of the conditions and warranties. There is no benefit of the conditions and warranties. So, whatever you are paying price reduced from the principal. Whatever the price you are paying treated as the rent every month. Done. Next, contract of sale versus contract for work and labor. In case of See, here I am painting the picture and giving it to you for 1000 rupees. Paper will be 5 rupees and my skill will be 19,909. I'm painting the picture of the Satvika, selling it to Satvika for 1000 rupees. Out of this, paper value 10 rupees and my skill value 990. Antena? So contract for work and labor. Contract for I'm selling the rare painting for 1 lakh. It is a contract for sale of the good. If I am charging 10,000 rupees, out of this 10,000 rupees, if majority is for the goods, contract of sale of the good, minority is for the service. It's a contract for sale of good because majority is for the goods only. Yes sir, no sir. Then now, if I'm charging 10,000 rupees, out of this 10,000 rupees, majority is for service. For example, we are paying 1 lakh rupees here. Out of this 1 lakh rupees, we give the books worth of maybe 1,000 rupees. Yes sir, no sir. Remaining 99,990 is for the teaching. It's a contract for work and labor. Contract for the. So, in case of sale of the goods, delivery of the goods is essential. Exercising of the skill is collateral. In case of the contract for work and labor, rendering of the service is essential. Delivery of the goods is collateral. If majority were charging for the goods, sale of good. Majority charging for the service, work and labor. Then next we discussed about the bailment versus sale versus bailment. In case of the sale, ownership will be transferred. Here only position will be transferred. Goods will not be returned. Goods will be returned. Consideration is compulsory. Here there can be gratuitous or the non-gratuitous bailment. We discussed already twice. One consideration chapter, bailment chapter, third time in Soga. 3 times we discussed. Then next concept is the goods. Next concept is the very important. Goods means every kind of movable property other than actionable claims and legal tender. So first one is the contingent goods. Which goods? Contingent goods means delivery of the goods depending upon the contingency which may happen, which may not happen. So I entered into contact with Satvika for sale of the watch. Where is the watch? Watch is inside the ship. Ship aaye to I will give you watch. Then yes or no sir? So sale agreement to sell, it is the agreement to sell. It will become sale if ship is reaching. It will become sale. So right now it is the agreement to sell. If ship is not reaching, contingency is not happening, ship dub gaya. Yes or no sir? Contract will be discharged. Content parties will be discharged due to non-acquisition. Next, future goods. So Satvika need a fan. It should have the 5 colors. How many colors, beta? Right now this kind of fan is not there. If you give me advance, I will manufacture. So these are the goods to be manufactured, produced, acquired after entering into contract of the sale. If you enter agreement, we will manufacture specifically for you. It is an agreement to sell. Due to strike, if I am unable to manufacture, whether contract is destroyed or no, the contract will not be discharged due to non-production of the future goods. Existing goods. Which goods? So Satvika father said, if you clear CA foundation, I will give you bike. She cleared CA foundation. Then Satvika and father came to my showroom. So many bikes are there. How many bikes? Vespas are there. So many Vespas. Yes sir, no sir. Clear na? So both of them came. Then there are so many Vespas are there. Right now it is with me in my shop. Existing goods. These are the goods which are owned and possessed by the seller at the time of contract of the 3 types. Unascertained, ascertained, specific. So 10 Vespas are there. How many Vespas? But she need only 1 Vespa. Those 10 Vespas are said to be unascertained goods which are not identified, which are not agreed. So out of this mass of 10 Vespas, Satvika selecting the white color Vespa. Which Vespa? I am keeping aside. Otherwise black color Vespa I am keeping aside. That is said to be ascertained. That is selected, identified and set aside. Identified and bazu lagaya. Then father came to me, he's asking how much is the Vespa. I said 2 lakhs. He gave 2 lakhs. Ready to buy, ready to sell, which is identified and agreed by the buyer and the seller. Specific. Then, and even this one is very important. Appropriation. Appropriation means selection of the goods with the intention of using the goods. In exam, he will ask what is appropriation and essentials of the appropriation. So, appropriation means there must be a unascertained goods. Which goods? So Satvika came to Kirana shop to purchase the nariyal. So outside the general store, one bag is there. Inside the bag, so many nariyals are there. All the nariyals are the unascertained goods. So the goods should be conform to the description, and the goods should be in the deliverable state. So nariyal we will do just like that only. We will not pack, and there must be unconditional contract. Which contract? It may appropriation may be made by seller with the consent of the buyer, or buyer with the consent of the seller, but generally done by the seller, because majority of the goods will be inside the shop. And it can be expressed, it can be implied, and assent can be given before appropriation or after appropriation. This whole box is very very important from exam point of view. Third question. Next one is the effect of destruction of the goods. 3 stars. How many stars, sir? In case of sale, in case of agreement to sell. In case of the sale, contract will become void if 3 conditions are satisfied. There is a contract for sale of the specific goods. Goods are damaged or so perished or so damaged as no longer to answer to their description. We discussed a beautiful case law example. So flowers become petals. Only stem baj gaya. Yes or no, sir? Can I call it as a flower? No. ఎంతగా ఖరాబ్ అయ్యాయి అంటే దాన్ని మనం ఫ్లవర్ అనలేము, అంతగా ఖరాబ్ అయింది. సో గూడ్స్ అండ్ గూడ్స్ ఆర్ డ్యామేజ్డ్. డ్యూ టు హూస్ ఫాల్ట్ గూడ్స్ ఆర్ డ్యామేజ్డ్? బయరా సెల్లరా? నాట్ ద ఫాల్ట్ ఆఫ్ బయర్, నాట్ ద ఫాల్ట్ ఆఫ్ ద సెల్లర్. సో కాంట్రాక్ట్ విల్ బికమ్ void. In case of agreement to sell, same 3 conditions plus one more condition, ownership is not transferred. There must be contract for sale of the specific goods. Goods are perished without the fault of buyer and seller, and ownership is not transferred. Risk is not transferred. Agreement will be void. And note also important, this will not be applicable to the unascertained goods. We discussed the example also, that cement bags example. 100 cement bags are there. I agreed to sell 10 bags. Whether I identify this bag bol kya? No. Whole 100 bags become stone. Whether contract is discharged? No. Because section 7 and 8 will not be applicable to unascertained goods. Next, document of title to goods. What is the document of title to goods? It is a document used in the ordinary course of business, which shows that you have the ownership on the goods. For example, you are shifting the vehicle from Hyderabad to Vijayawada through railways. When you are loading the vehicle in the Warangal station, railways will give the slip as a receipt. The receipt talk about the document of title to goods. This document saying that you have the ownership on the particular bike. If you show the same receipt in the Secunderabad station, they will release. Yes sir, no sir. It is a document used in the ordinary course of business which shows that you have the ownership on the goods. Title means ownership. Title means ownership. Title, property, ownership, all are same. Various kinds of documents will be there. Bill of lading given by the captain of the ship, authorizing the owner of the goods to receive the goods at the destination. Dock warrant issued by the dock authority. Warehouse keeper certificate or the wharfinger certificate. Wharfinger is the warehouse nearby the seaport. When you are keeping any goods there, he will give the document. Railway receipt, just now we discussed. Delivery order given by the transportation companies like Agarbal movers and packers. And share certificate is a document showing the title, because share is the good on the share itself. We are writing the ownership. Document showing the title. Then we discussed the price, which is very very important from exam point of view. Star, superstar, and a bit of mega star. So how to fix the price? Price may be fixed by the contract by mutual consent. It may be fixed in an agreed manner, like cost plus 20%. It may be fixed in the based on the course of the dealings. 2010, 10 rupees. 2011, 11 rupees. 2012, 12 rupees. 2013, how can you say 13 rupees? Based on the course of dealings. So if the price is not fixed, we have to pay the reasonable price. Price can also be fixed by the third party. If third party is unable to fix the price, contract will become void. If third party is unable to fix the price due to fault of seller or due to fault of buyer, aggrieved party can claim the damages from the other party, but we have to pay reasonable price if he has already used the goods. Then this is all about the revision of the chapter 1. Clear? So in the next class we'll do the scanner. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Yeah, welcome back, sir. So in the last class we have completed conditions and warranties. We'll revise rapid revision. First of all, what is conditions and warranties. This chapter is one of the important chapter in the SOGA. Representations. Whenever we enter into contract of sale of the good, seller will explain what he has, buyer will explain what he needs. What he needs. There are certain representations. For example, being a seller, I said, I have the car, Jaguar car, 2020 model, beautiful car, black car, lucky car, petrol car. All these are the representations. And buyer said, I need a car, mileage, the budget will be 70 to 90 lakhs, and it should be related to 2018 to 22 model, nice car and comfortable car. Out of all these explanations, representations, few things are the facts, few things are the opinions. Few are opinions, few are the facts. Car, fact. Jaguar, fact. 2020 model, fact. Beautiful, opinion. Black, fact. Lucky, opinion. Petrol is the, in the same way, she need a car, budget 70 lakhs. These are the facts. And nice car is the opinion. Comfortable car is the, we don't consider opinions in the sales of goods act because which are uncertain. Done. So whenever we enter into contract of sale of the good, seller will explain what he has, buyer will explain what he needs. All these explanations are said to be representations. Some of the explanations are the opinions which will not form part of the contract. Some of the explanations are the facts which will become form part of the contract. Yes or no, sir? Those representations which are facts are said to be stipulation. Stipulation is a representation which is fact. So it is a stipulation. It is stipulation. It is a stipulation because this is the fact. It is not a stipulation. It is a stipulation. It is not a stipulation. Then so stipulations are of two types. If that stipulation, if that fact is essential for performance condition. If that fact is collateral for performance, that will be warranty. For example, when we are selling the bottle, cap should be there. It is essential. Cap needed the same color, warranty. It can be different color also, no problem. Yes or no? So if it's same color, it looks more beautiful, but it is not compulsory. I am selling the fan. 3 wings are the essential. Out of these 3 wings, 1 wing is different color. Nothing will happen. Warranty. Then, yeah, if the stipulation is essential for performance, set to be condition. In case of breach of condition, buyer can reject the goods and he can claim the damages. So I am selling a fan without any wings at all. Breach of condition, he can rescind the contract, he can claim damages. I am selling a spectacles without having a glass at all. Breach of condition. Breach of condition. You can rescind the contract, claim the damages. Breach of condition can be treated as breach of warranty. Very, very important. Actually, I am selling a fan without any wings. That motor is there, wings are not there. Breach of condition. Buyer said, no problem, sir. Earlier, I used to have the fan. That motor is kharab ho gaya, but wings are there. I will attach those wings. That means what he is doing, instead of cancelling, he is accepting the defective goods. He is treating breach of condition as a breach of warranty. So, warranty is a stipulation which is collateral for the performance. In case of breach of warranty, you cannot rescind the contract. You can claim only damages because it is only collateral. Breach of warranty cannot be treated as breach of condition. And you purchase the bike because clutch is so tight. Can you rescind the bike? If you go to workstation, they will fix it. Then done. Next term, this is very, very, very important, sir. We can treat breach of condition as breach of warranty. When breach of condition is treated as breach of warranty, SOGA itself is giving some examples. These 3 examples are very, very important. Exam, I see a favorite question. CMA, CA, I see a favorite question. Where buyer is waiving the condition. Waiving means give up. Buyer said, even essential thing is missing, I will not rescind. What does it mean? Is not rescinding means claiming it as a warranty because it's demanding only damages. Second one, buyer treating breach of condition as breach of warranty. So buyer has right to terminate the contract, but not terminating. What does it mean? Treating breach of condition as breach of warranty. Third one, if the contract is not separable, buyer is accepting part of the goods. Can I separate the bottle and cap? No. Can I separate the button and shirt? No. If the contract is not separable, if buyer is accepting part of the goods. Yes or no, sir? That means he is stating breach of conditions, breach of warranty. Very, very important. These conditions of warranty are of two types. One is express, other one is implied. If the conditions warranty is given by act, implied. Conditions and warranty specified by the buyer and seller by mutual consent, expressed. Done. So express conditions can be anything that depends upon the buyer and the seller. Implied conditions are of 8 conditions given by act itself. First one is the condition as to title. Title means ownership. Buyer will assume that B seller is having the ownership on the goods in case of the sale. In case of the seller has the right to sell the goods. In case of agreement to sell, seller will have the right to sell the goods. If seller selling the goods without having ownership, there is a breach of condition as to title. Buyer can resign the contract. Done. So we have seen one that example also. Having ownership is different. Having transfer of ownership is different. So someone is buying the goods from another country where there is infringement of trademark, Nike, Puma. So customs are freezing these goods, seizing. Customs authority said, we will not release the goods unless you remove the logo. Here, even the buyer is the owner, the buyer cannot transfer the ownership to someone else. Done. Second one, condition as to description. Goods being sold should correspond with the description given. Again, it is 3 types, where buyer has seen the goods, where buyer has never seen the goods. Third one is the method of packing is described. That one is very, very important, method of packing. Bottles. Each quarter should have the 10 bottles, but we are supplying the 5 bottles. Can he reject the goods being a buyer? Yes. Next, condition as to sample. Goods delivered should correspond with the sample given. However, it is the duty of the seller to give a reasonable opportunity to buyer for comparing the sample with the tendered goods. And goods should be free from the hidden defects. Hidden defects, for apparent defects, who is liable? Buyer only responsible. For hidden defects, seller will be liable. Condition as to sample as well as the description. Sample has to match, even description has to match. If any one of these are not matching, there is a breach of condition as to sample as description. You can rescind the contract. Next one is the condition as to quality and fitness. Very, 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 very important, because all the conditions are the exceptions to condition as to quality and fitness. There is no condition as to quality and fitness. This is quality good. We can't decide like that. Depending upon the person to person. Someone like the Crompton AC, someone like the Bajaj AC, someone like some other company AC. Which AC is quality AC? It is not defined. Yes sir, no sir. It is the duty of the buyer to choose the goods which will satisfy his requirements. Also known as caveat emptor. Generally, seller will not be liable for the wrong selection of the goods by the buyer. We have some exceptions. So, on these exceptional cases, who will be liable? Seller will be liable. First one, the particular purpose for which goods are required must have been disclosed by buyer to seller. Since the buyer is disclosing to seller, Babu, this is my purpose, you choose the good. Then who will be responsible? Seller will be responsible. We discussed a case law also, priest versus last. There's water bottle. Yes or no, sir? Buyer said, I need a bottle which can able to hold the boiling water. Which water? I give the bottle. So that was burst. Who will be liable? Seller will be liable. Next, second one. Buyer must have relied on the seller's skill and judgment. Whose judgment? Seller's skill and judgment. Then who will be liable? Seller will be liable. Because buyer said, I am depending upon your skill. There is a famous case law, Baldry versus Marshall. This was asked so many times in the exam also as it is. 5 stars. Yes sir, no sir. So what was happening in this case law? One guy will be traveling in the hilly areas. Which area? He said, I need a car which is suitable for the hilly areas. But which car the dealer is suggesting? Bugatti car, sports car. Unfit for the traveling in the hilly areas. He is supposed to suggest the SUV, sport utility vehicle, like Hummer. Yes sir, no sir. Since it is like otherwise Thar. Yes sir, no sir. Since it is a sports vehicle, no, unfit for the traveling in the hilly areas, there is a breach of condition as to title. This case was asked so many times. Baldry versus Marshall. Next, the seller's business is to sell such goods. That is the expert seller. Which seller beta? Here, who is responsibility? Seller responsibility, because seller is expert. So we discussed a case now also, Dr. Barreto versus Cruz. Here, a doctor is selling the farm's artificial teeth setup. but it is unfit for the patient mouth. Who is responsible? Seller will be responsible. Condition need must be fulfilled if the goods can be used only for particular purpose. We have discussed the case law, Evans versus Tilly Benjamin. Here, the seller is selling a refrigerator, but that refrigerator doesn't make the ice. So, who is responsible to sell the refrigerator which can able to make the ice? Seller is responsible. Who is responsible? And non-applicability. This will not be applicable in two cases. One is the where buyer fails to disclose the abnormal circumstances. We have seen a case now, Griffith versus Peter Company Limited. Here, one lady will be there. Her skin is so sensitive. She was purchasing a dress from the shop. After wearing the dress, she was getting the rashes. Who will be liable? Buyer is liable because buyer fails to disclose the abnormal circumstances to seller. Yes or no, sir? Last one, where buyer purchase the goods under the trade name, brand name. Here we have seen example, Complan. You are purchasing a Complan bottle on the brand name, but not on my shop name. Yes or no, sir? Seller will not be responsible. Who will be responsible? Buyer will be responsible. Next one, condition as to merchantable quality. It means goods should be good enough condition to be purchased and sold as such. For example, I am selling the pen beta where there is no cap. Can you sell it as a pen? No, because cap is not there. I am selling a chair, it is having only 3 legs, one leg is not there. Can you sell it as a chair? అది ఆ వస్తువులాగా కొనబడాలి, అమ్మబడాలి. I am selling a book where there is no that main paper, atta. Can you sell it as a book? No. Yes sir, no sir. Goods must be sold and purchased as such. ఆ విధంగా కొనబడాలి, ఆ విధంగా అమ్మబడాలి. Otherwise, there is a breach of condition as to merchantable quality. We have seen an example. Someone went to the supermarket, he was taking the water bottle or some bottle. Well, examine the bottle that was burst, exploded. Yes sir, no sir. Is it merchantable quality? No, it is not a merchantable quality. అలా అమ్మడానికి కొనడానికి అనువుగా లేదు అది. ఎస్ సార్ నో సార్. అండ్ దిస్ కండిషన్ విల్ బి అప్లికబుల్ ఈవెన్ యూ పర్చేస్ గూడ్స్ అండర్ బ్రాండ్ నేమ్ అండ్ ట్రేడ్ నేమ్. అండ్ seller will not be responsible if seller give the reasonable opportunity to buyer for verification of the goods. We have seen the tur dal which was damaged. Still you purchased it. Whether seller is responsible? No. And we have seen the catapult example. Which example? Catapult. So this was so tight that is supposed to be elastic in nature, but rubber is not elastic in nature. Whether seller is responsible? Yes, because it is not merchantable quality. Which quality? Next term, condition imposed by custom. So we have seen a case law also, beta. So RK beach. In the RK beach, there was a custom. There is a tradition. So the fishermen, when they sell the goods which they found in the sea, they have to inform the customer, Babu, it is a sea damaged good. Which good? If seller sells the goods without following local custom, it is breach of condition as to custom. Sir, what different from here and there? The same thing we discussed in the warranties also. Customs. In one vegetable market, inside the market, you got sell A quality apple. Which apple? If you selling the B quality apple in the Eragada market, in the Esther Nagar market, Esther Nagar vegetable market, buyer can rescind the contract. Buyer can? Because Esther Nagar people, Esther Nagar vegetable market treating it as a condition. Eragada market treating it as a warranty. There you can claim only damages. In one market, in both the market, you have to sell the A quality apple only inside the market. You can sell B quality outside. But one market treating it as essential, one market treating it as a collateral. Then last one, condition as to wholesomeness. It is applicable only to foodstuff and eatables. If goods being sold are unfit for the human consumption, there is a breach of condition as to wholesomeness. Buyer can rescind the contract and claim the damages. Next, we discussed implied warranties. There are 4 warranties will be there, beta. First one, warranty has to quite a position or unlisted position. Being a buyer, he will assume that once I purchase the remote, I can enjoy the physical position of the remote. I sold the goods, but I am not given the physical position. He is unable to enjoy the physical position of the goods. There is a breach of warranty as to void position. Since it is a warranty, buyer can claim only damages. Next one is the warranty has to free from the encumbrance. Encumbrance means girvi, takattu, charge, security. Being a buyer, he will assume that seller is selling the goods which are free from the encumbrances, all the charges. If seller selling the encumbered goods, there is a breach of warranty as to encumbrance, and buyer can claim the damages. Condition as to quality and fitness. Warranty as to quality or fitness annexed by the usage of the trade. In particular market, like Eragada market, we have to sell A quality apple only. If we are selling B quality apple, breach of warranty. Breach of the same thing in SR Nagar, breach of condition. In SR Nagar, you can return the apple, get back your money. There, you can claim only damages. What is the damage? A quality apple 50 rupees, B quality apple 40 rupees. How much you can claim only? 10 rupees. In Eragada. In SR Nagar, you can give back the apple, get back your 50 rupees also. Rescinding. Then, last one, warranty to disclose the dangerous nature of the goods. It is a duty of the seller to disclose the dangerous nature of the goods on the article. For example, acid bottle, we have to handle with care. If is unable to disclose the dangerous nature of the goods on the article, there is a breach of warranty to disclose the dangerous nature of the goods. We discuss the case law of Clark versus Army and Navy Cooperative Society. Here he is selling some disinfect powder, that is bleaching powder. We have to open carefully, otherwise that may enter into your eyes. We have to write how to open the packet on the external packet. Yes or no, sir? Otherwise, there is a breach of warranty as to disclose the dangerous nature of the goods. So, with this, we have done with revision of the conditions and warranties. Remaining part we'll discuss in the next class. Have a great time. Enjoy the day. We'll do the scanner in the next class. So, welcome back, sir. In the last class, we have completed transfer of property. We'll have the rapid revision of transfer of property. Topic 3 in the SOGA, sales of goods. First of all, what is the meaning of property? Property means ownership. Property means transfer of property means transfer of ownership. Transfer of from the seller to the buyer. It's said to be transfer of ownership. So, transfer of ownership means transfer of absolute legal ownership. Absolute. The ownership on the goods is transferred from seller to buyer. The timing of transfer of ownership is very important because it will decide the rights and duties of the buyer and the seller. If ownership is not transferred, seller has to bear the risk of loss of the good. If ownership is transferred, buyer has to bear the risk of loss of the good. So, what is important? Timing of transfer of ownership. What is important? Is very, very important. In this chapter, we will discuss at which point of time ownership will be transferred. See, to decide the risk and to decide the risk, if ownership is transferred, buyer has to bear the risk of loss of the good. If ownership is not transferred, seller has to bear the risk of loss of the good. It is immaterial who is having the possession. Who is having the possession? In SOGA, 3 things will be there. One is ownership. Other one is payment. Other one is delivery. Secondary priority, ownership is important. Who is having the possession is not important. Who is having the ownership is important. The person having the ownership has to bear the risk of loss of the goods irrespective of possession and to decide the price. If ownership is transferred, then only we can demand the price. Ownership is not transferred, we can't demand the price. So that's why point of transfer of ownership is very, very important. If ownership is transferred, we can ask for the price. If ownership is not transferred, we can't ask for the price. Then, so that's why at which point of the ownership transferred is very, very important in the SOGA. Then, so next one, rules regarding the transfer of ownership. Rules regarding the transfer of ownership. This chart is the crux of the whole chapter, beta. Yeah. When ownership will be transferred in case of the specific goods, when ownership will be transferred in case of the uncertain goods, when ownership will be transferred in case of goods and on approval basis, when ownership will be transferred in case of reservation of right of disposal. These 4 things are very, very important. Let us start with the first one. When ownership will be transferred in case of the specific goods. First of all, what is the meaning of the specific goods? Specific goods are the goods which are identified and agreed upon at the time of contract of sale. We discussed in the first chapter. In case of specific goods, ownership will be transferred when the parties are intended to be transferred. कब सोचे तो जब ट्रांसफर होता ఎప్పుడు అనుకుంటే అప్పుడే ట్రాన్స్ఫర్ అవుతుంది. In case of specific goods, ownership will be transferred when the parties are intended. When the parties are, then what is the meaning of intention? This intention is of three types. How many types, beta? 20, 21, 22. When the parties are intended, when the parties are to be transferred. So intention is of three types. How many types? Three types. First one, where there is a contract for sale of the specific goods. Which goods? Which are in deliverable state. Which state? Deliverable state. If these two conditions are satisfied, ownership will be transferred when the contract is made. We discussed one example. Hai. So I have a shop, SG Kirana and General Stores. Rajni came to my shop afternoon 11 o'clock. When beta? Or morning 11 o'clock. She said, Srina sir, I want Rexona soap. A soap? Whether we have to pack it? No, it is deliverable state. So many soaps are there. Santur is there, Rexona is there, Lux is there, Medimix is there. She said, I want Rexona. One soap is there, no Rexona? Once upon a time, nowadays it's not famous, but once upon a time very famous. Yes sir, no sir. So, it is a specific good. Which good? Out of 10 soaps, she said, I want Rexona specified. It is deliverable schedule, we need that pack. So, ownership will be transferred when the contract is entered. We entered into contract at 11 o'clock. She is ready to buy, I am ready to sell. Ownership will be transferred. Second one, where there is a contract for sale of the specific goods not in deliverable state, not in. We discussed one example, gift article. Which article? So Rajini came to, I have a shop, SG Arches Gallery, where I sell the gift articles. Yes sir, no sir. She said, my friend getting married, Sahiti, so I want to gift something to Sahiti. Dekho beta, what do you want? Radha Krishna, lovebirds, Taj Mahal, so many things are there. She said, I want Radha Krishna. Clear na beta? But we have to bring it down, we have to clean it, we have to pack it. I said, "Dede kya? No, we have to pack it, we have to wrap it." Yes sir, no sir. So not in the deliverable state. So she was asking the Radha Krishna idol, 11 o'clock. I said, yes, 1,000 rupees. She said, okay, sir, 1,000 rupees is okay. But we have to put into deliverable state. I said, Rajini, give me some time. Give me some time. So we have to bring it down, we have to clean it, we are keeping in the box, we are packing, we are keeping the red rose, arrows attaching, and we are attaching the sticker, best wishes. This was happened by 11:15. When I said to Rajini also, Rajini, your article is ready for delivery. Ownership will be transferred at 11:15. So ownership will be transferred. Seller puts the goods into deliverable state, packing is done, and buyer has the notice. Buyer has the notice. Then ownership will be transferred. There is a contract for sale of the specific goods in deliverable state, but seller has to do something to ascertain the price. We discussed about the jaggery. Yes sir, no sir. So Rajini came to my shop to purchase jaggery. Is it in deliverable state? Yes, it is in deliverable state. But we don't know the weight of the jaggery. Kg 40 rupees. Kg. That block may be 200 grams, 300 grams, 500 grams also. I said, give me some time. I have to keep it on the weighing machine. Which machine? She was asking that at 11 o'clock, but I was keeping it in the weighing machine at 11:05. When I said, this is 500 grams, you have to give it 20 rupees. You have to give. So ownership will be transferred when seller does that activity, keeping on the weighing machine, and buyer has the knowledge. I said to Rajini, it is 500 grams, you have to give 50, 20 rupees. How many rupees? Ownership will be transferred. So, what is the meaning of the unconditional contract? Which contract, beta? Unconditional contract means without having any condition, without having any. I am not keeping any if condition. I will give you this article if you clear CA, something like that. Whether I am keeping any condition. When there is, what is the meaning of deliverable state? Which state, beta? Deliverable statements, which is state at which buyer would take the delivery of the goods just like that. We need to pack it again. Bolo. Unconditional contract means a contract containing no condition regarding transfer of ownership. Whether I am keeping any condition, no, unconditional contract. Deliverable state means state The buyer would bound to take the delivery of the goods. Deliverable state. A state. Next, done with specific goods which are into deliverable state. Where there is an unconditional contract for sale of the specific goods which are into deliverable state. A state. Next, unascertained and future goods when ownership will be transferred. In case of unascertained and future goods, ownership will be transferred if the goods are ascertained, unconditionally appropriated by the buyer or seller with the consent of the other party. What is the meaning of ascertainment? So Rajni came to my shop to purchase nariyals, coconut. So outside the shop, I'm keeping the bag. In that bag, 50 nariyals are there. How many nariyals? Coconuts are there. So all they are the unascertained goods. Which goods? Out of these 15 nariyals, Rajni selecting one nariyal. That is ascertained. That is, then she is asking me, Srinath sir, will you sell this nariyal? I said, yes. How much? 50. She said, yes, sir, ready to take. See, she is selecting one nariyal. This was ascertained. That was, she is asking me, Srinath sir, are you ready to sell this nariyal? I said, yes. How much? 50. So goods must have been unconditionally appropriated by the buyer or the seller. Whether I'm keeping any condition? No. With the consent of the other party. Then if the goods are inside, I will select the goods with your consent. If good is outside, you have to select with my consent. Ownership will be transferred. Ownership will be. What is the meaning of the ascertainment? Ascertainment is the process of identifying the goods, and setting apart. It is a unilateral activity generally done by the seller. MCQ in CMA. Ascertainment means process of identifying the goods and keeping the goods asset for the purpose of sale. It is a unilateral activity done by the seller. Because most of the goods will be inside the shop. Very few things will keep outside the shop. Appropriation. Next one is the appropriation. Appropriation means selection of the goods. Appropriation means selection of the goods with the intention of using the goods. Then, yes sir, no sir. Fair enough. This is very, very important. We will ask in the exam. We discuss in the first chapter also. What is appropriation and essentials as to appropriation. Essentials of the appropriation. Goods must be conformed to description and quality. So goods should be as per the description. Goods must be in the deliverable state. And goods must be unconditionally appropriated. It may be done by seller with the consent of buyer. It may be done by buyer with the consent of seller. It may be expressed. It may be implied. It may be done before or after appropriation. Assent may be given by the buyer or seller before or after appropriation. Then next, goods sent on approval basis. Goods sent on, it is known as the retain or return basis. Retain or return. So I'm giving you some goods. If you like it, use it first of all. If you like it, return. If you don't like, return. वापस कर दो. Goods sent on approval basis. बेटा section 24. This will be very, 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 very important from exam point of view. This was asked so many times in the exam. How many times? See. 1, 1, 27. I am giving some goods to Rajni. I am giving the bike to Rajni. Rajni said, Srinath sir, I will use the bike for 10 days. How many days? 10 days. If I like the goods, I will keep the goods. If I don't like, I will return the goods. Goods sent on approval basis. If she approve, it will become sale. If she is not approving, it will be cancelled. Then, for example, she was using the bike on third day itself. She liked that particular bike. She informed me on third day morning 10 o'clock. She made a call to me. She said, I like your bike. I am taking your bike. I am giving my approval. Ownership will be transferred on the third day 10 o'clock. 11 o'clock car jal gaya. That bike jal gaya. Who should bear the risk of the loss of the good? Buyer. Then otherwise, second option. है ना? So on fourth day, another example. On fourth day, she made a. So I gave the blue color Avenger to Rajni for 10 days. On fourth day, she is changing the color. She is changing the blue color bike with black color bike. On fourth day, she is selling it to Sahiti. She is selling it to Sahiti, third party. Selling it to third party, Sahiti. Or she is pledging the bike with Sahiti. Pledging means Takatu, Girivi. Yes or no, sir? She is pledging the bike with Sahiti. Why she is doing all this? Why she is changing the color? Because she is accepting. Why she is selling to someone? Because she is accepting. Why she is pledging the goods? Because she is accepting. When she does anything, when she does, which shows that she is accepting the goods, ownership will be transferred. Last bench. On the fourth day, what is doing beta? Changing the color, changing the body shape, changing the selling it to third party and pledging with third party. Ownership will be transferred. This page was asked so many times in the exam. Otherwise, next example, she said, Rajni said, Srinath sir, I will use the bike for some days. How many days? If I like the bike, I will keep it. Otherwise, I will return it. Some days means it must be reasonable time. Which time? If time is specified, 10 days. How many days? Sir? 10 days. Ownership will be transferred on expiry of the 10th day. If time is not specified, time is not specified, but ownership will be transferred after expiry of the reasonable time. Which time? Reasonable time is a question of fact depending upon the facts and circumstances. First one. So, when buyer signifies the approval, ownership will be transferred. Ownership will be, when approval is communicated, the ownership will be transferred. In our example, third day. Which day? First example, like you know, on third day itself. Then, when buyer does some act, adopting the transaction, that means he is selling the goods, he is pledging the goods. Sahit is selling the goods, pledging the goods, changing the part of the bike. Yes or no? So ownership will be transferred. Otherwise, when buyer fails to return the goods, if time has been fixed on expiry of the specified time, 10 days. If time is not specified, on expiry of the reasonable time, ownership will be transferred. Clear na? Everyone. Next, goods sent by the reservation of right of disposal. Reservation of disposal means seller is reserving the right of the buyer to use the goods. And I am giving the goods, but not the ownership, until some condition is satisfied. We discuss one example today's puja in our home. Some festival is going on in our home. Mama will prepare yummy food. Whether she will allow you to eat it? No. One condition. Condition is we got to complete the puja. We got to offer it to Bhagwan. Then we can eat. Until puja completes, don't touch it, don't eat it. She is reserving the right from using. From goods sent on, reserving means restricting. Reserving means disposal means using. Restricting the right of the buyer. Restricting the right of the from using the goods until some condition is satisfied. Until generally the condition will be non-payment of the price. Until you pay the price, I will not give the ownership. Until you pay the price, I will not allow you to use it. It is a conditional appropriation. Which appropriation? Conditional. What is the condition generally? Pay the price. Pay the price. Then only I will allow you to use it. Otherwise, I will not allow you to use it. Otherwise, I will not transfer the ownership. Conditional appropriation. So, where there is a contract for sale of the specific goods and which has been subsequently appropriated to the contract, the seller by the terms of the contract or appropriation, as the case may be, reserving the right to dispose the goods, reserving the right to use the goods until certain conditions are fulfilled. So you should not use the goods until some condition is satisfied. That means property. Property means ownership. Property therein will not pass to the buyer till condition imposed by the seller is fulfilled. So ownership will not be transferred until you fulfill the conditions. You can't use the goods until you fulfill the conditions. Then, so there are a few cases. Is there beta? Deemed to be reservation of right of disposal antam. For example, I am sending some goods from Hyderabad to Vizag. Hyderabad, SG is there. In Vizag, Sahiti is there. I am sending the 100 rice bags through railways, through a track, a railway track. Sending the goods through railways. So when I'm loading this goods in the railways, no, but they will give the receipt. They will give the receipt. है ना? The receipt is taken in the name of the who is the seller? Seller. It's a seller. Taken in the name of the seller. So the receipt is in my name. So after reaching Vizag, can you claim the goods from the railways? No, because seller is reserving the right of disposal because the document is in whose name? Beta? Seller name. If railway receipt is taken in the name of the buyer, in the name of the, but it is sent to bank. I am taking the receipt in your name only, but I am not giving it to you. I gave it to bank. You have to go to bank, deposit the money in the bank, then bank will give the receipt, then you can take the goods from railways. So here also, whether I am giving the chance to take the goods, no, until you pay the price. Seller is reserving the right of disposal. Third one, if railway receipt is taken in the name of the buyer, I am taking the receipt in the name of the buyer and I gave it to buyer also. Whether I am reserving a right of disposal, no, because the receipt is taken in the name of the buyer. I give the receipt to buyer. You can show the receipt in the railways. You can take the goods from railways. Done. Last one. In case of bills of exchange, so I am sending some goods. I am sending we discussed car example. I am selling the cars to Sahiti. Through how many cars I am selling, beta? 10 cars, 10 Alto cars, because I am a wholesaler. This is a retailer in the Nizamabad. Through that particular goods carriage, which carriage? Container lorry. So how many Alto cars have you, beta? Brand new, 10 cars. Who is the driver? Rajni is the driver. Rajni, go to Nizamabad, unload the cars with Sahiti and give the bills of exchange. Give the bills of exchange. If she is honoring the bills of exchange, give the documents. If she is not honoring the bills of exchange, no, don't give the documents. What does it mean? Here I am not reserving the right of disposal because documents I am giving car documents to buyer. Here I said if she is not paying the money, if she is not honoring the bills of exchange, don't give the documents to buyer. What I am doing here? Reservation of right of disposal. Cards are given to Sahathi. Can she able to sell? No, because keys are not given, documents is not given. Done. Next concept is the passing of the risk. Passing of the, but whoever is having the ownership, they will have the risk of the goods also. If ownership is transferred, the risk will be transferred. If ownership is not transferred, the risk will not be transferred. Risk and ownership will go together. Risk and ownership will go. So passing of the risk prima facie pass with the property. Risk and ownership will go together. If ownership is transferred, buyer has to bear the risk of loss of the good. If ownership is not transferred, seller has to bear the risk of loss of the good. If ownership is not transferred, seller has to bear the risk of loss of the good. So risk and ownership will go together. Will go. If ownership is going, uska piche risk will go. If she is having the ownership, she has to bear the risk. If I am having the ownership, I have to bear the risk of loss of the good. If he is having the ownership, he has to bear the risk of loss of goods. Then because they are like wife and husband, they are like shadow. Wherever you go, it follows you. Shadow. Then beta. Generally, risk and ownership will go together. That is said to be risk prima facie on the face pass with the property. Property means ownership. Risk means risk of losing the goods. There are few exceptions are there, but in this exceptional cases, we can separate the risk and the ownership. First one is the contract agreement to contrary. We discuss one example. By express agreement, we can separate risk and ownership. So, in Amirpet, I have a shop, SG Mobiles. So, Sahiti came, 11 o'clock, she purchased the mobile on 10/10/27, 10/10. But we give 6 months guarantee. How many months guarantee? In the 6 months, even the mobile is with you. If something happens to the mobile, I will take the risk. I will bear the risk. What we are doing here? We separating the risk and the ownership. Ownership is with Sarati, risk is with the SG. First 6 months. I am agreeing, she is agreeing. Yes sir, no sir. Next one, delayed delivery. We discussed the famous case la Dimby Hamilton Company Limited versus Barden. So irrespective of the ownership, party at default has to bear the risk of ownership. You know, if it is your fault, you have to bear the risk. If it is my fault, I have to bear the risk. Then we discussed the case also about sugarcane juice. Clear na? Sugarcane juice is perished because of fault of the buyer. Buyer has to bear the risk of loss of the good. Sugarcane juice is perished because of fault of seller. Seller has to bear the risk of loss of the good. Last one, by usage of the trade. We discussed that example. Glass dining table. Where we purchased Nampalli. Where is the delivery in Kukatpalli? No, but generally, buyer become the owner in the Nampalli itself, but seller said, we will bear the risk until goods reaching the Kukatpalli at your home. Who will do this? Only me, yeah? Everyone in the industry? Everyone in the industry. In that market, every seller will take the risk until goods reaches the buyer home. It's a custom. It is usage of the trade. So you become the owner in the Nampalli, but risk is with me till it reaching your home. We separate risk and ownership. Then, yes sir, no sir. Last concept in this chapter will be non-code habits. Namo.code non-habit, which means no one can give what he himself does not possess. This concept is very, 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 very important from exam point of view. The beauty of this question, direct question in the exam. Non-code habit, explain along with exceptions. That's it. General rule, code non-habit, no one can give what he himself does not possess. If I have the ownership, I can give you ownership on the good. If I don't have ownership, I cannot give you ownership. If I have knowledge on the law subject, I can give you knowledge on the law subject. I don't have any knowledge on the law. Can I give you knowledge? I have knowledge in the auditing. Can I give it to you? Yes. I don't know C++ Java. Can I give the knowledge of the C++ to you? No. Namo dot code non habit, which means no one can give what he himself does not possess. If seller does not have ownership, buyer cannot get the ownership. Which one? If seller has the bad title, defective title, buyer will get a bad title, defect title only. నా దగ్గర ఏముందో అదే నీకు ఇవ్వగలను. నా దగ్గర లేనిది నీకు ఇవ్వగలనా? ఇవ్వలేనే. Three exceptions are there. What are they? Around 10 exceptions are there. In these exceptional cases, even seller does not have the ownership. Still, buyer will get the ownership. So, पहला वाला sale by mercantile agent, sale by joint owners, sale by a person under the voidable contract, sale by the seller in possession after sale, sale by buyer in possession of the goods before sale, sale by the unpaid seller, sale by the finder of last goods. एक देखेंगे. First one, sale by mercantile agent. These things you have to write in the exam. ABC. And this case law is very, very important. Fox versus the king. First one, sale by mercantile agent. Here, even seller does not have the ownership, buyer will get the ownership. Pull and look at the screen. It's being recorded. You become famous. Sale by mercantile agent. Mercantile agent means employee. Simply employee. So I went to car showroom to purchase the car. To purchase the car. Tata Motors showroom I went. There Pulender was sitting. Marketing agent. Which agent? Marketing agent. Whether he is the owner of the car, just employee 10,000 rupees per month, 20,000 rupees per month. Then Pulender said to me, sir, good morning, sir. What do you want? In English. I said, I want car. I want. Then he's showing the Tata Tiago. Tata? Yeah. I impressed by his explanation. He said, sir, there is a car, Tata Tiago, beautiful car. Which car? It has 4 wheels. How many wheels? 1 steering. How many steerings? Smooth car. Which car? I liked by his description, explanation. I purchased. I'm asking how much is the car? 10 lakhs. How many lakhs? Fatafat, I got 10 lakhs. Fatafat, he transferred the documents to me. Whether he's the owner of the car, will I get ownership? Yes. Even he's not the owner of the car, I will get the ownership on the car. Then, because here, Pulender, the employee, is in the position of the goods or documents, is acting in the ordinary course of business. I purchase the goods in good faith. Then, there was a famous case about Fox versus King. Very, very important. This question came so many times in the exam. So, what was happening in this case? I have a car, SG. I said to Gopal, Gopal, sell it to for 50,000 rupees. Is my mercantile agent. Which agent, beta? Mercantile agent. He is my agent in the business to sell the goods on my behalf. But Gopal will not listen to me. Gopal sold the car to Satish for 40,000 rupees. Will Satish will get the good title? Yes. Then can I recover the car from the Satish? No. Because here goods is sold by the mercantile agent and he is acting in the ordinary course. Buyer is acting in the good faith. This question came so many times in the exam. As it is. Sale by joint owners. Sale by the joint owners we discussed yesterday. One example. Pulendra and his friend Santosh. Santosh ana సార్ పేరు శివరామకృష్ణనా పులి పులికో ఫ్రెండ్ శివ jointly purchase the bike. This one also he will ask me the practical question beta. Puli and Shiva purchased a car. Beta purchase the bike. 2 lakhs rupees. So 1 lakh contributed by Pulender, 1 lakh contributed by the Shiva. करना बेटा. So पीछे टायर किसका है? पुली. सामने का टायर किसका है? शिवा. हेडलाइट किसका है? शिवा. टेल लाइट ना? पुली. Joint owners. Which owners? One fine day Pulender went back to his village for farming purpose. Yes or no, sir? Then Shiva also decided to go back to his village. But right now bike is with whom beta? Shiva. Done na? So Pulender said to Shiva, Shiva, you can sell the bike. You can sell the. But Shiva is having only part ownership, joint owner, part ownership only there. And Shiva selling the same bike to Navadip. Edit, he likes second hand item sell out. Yes sir, no sir. Clear na? So even Shiva is having the part ownership. Navadip will get the full ownership on the bike. If the goods are under the joint ownership, the one of the joint owner must be in the position of the goods, and Shiva is selling the bike with the consent of the Pulender, and buyer is buying the goods in good faith. Which way the? Next, sale by a person in possession under a voidable contract. Which contract? So we discussed who is this A auntie, right? G ante Ganesha. One fine day. One fine day. Ganesh kept the gun. The gun है बेटा. क्या है बेटा? Gun against the auntie. Anjali auntie. Which auntie? Taking the necklace. Taking the necklace. Voidable contract. Whether is Ganesh having a good title? No. Bad title because keeping the gun is a voidable contract. Coercion. Before Anjali going to court of law. Before Anjali going to police station. This Ganesh. So Ganesh is having a bad title. Which title beta? Ganesh sold it to Bazwala auntie. Which auntie? A Bazwala auntie beta. Bhavani auntie. Which auntie? He sold it to Bhavani auntie. Bhavani aunt don't know about this coercion. Will she get the good title? Yes. Even he is having a bad title because it's a goods sold under a voidable contract. The seller is in position of the goods under a voidable contract. Which contract? And the contract is not rescinded by the Anjali auntie when he is selling. And this Bhavani auntie purchasing the goods in the good faith. And the buyer is not aware of the defective title of the Ganesh. Even he have the bad title, she will get the good title. Then next, sale by the seller in possession after sale. After, so we discussed smooth, slim, black, sleek TV. Yes sir, no sir. So here SG electricals are there beta. And Satish came, he liked the TV, he purchased the TV, He paid the money also. Ownership is transferred to whom, beta? Satish. But Satish said, sir, I will come in the evening, I will take the TV. Position is with seller, ownership is with buyer. Subsequently, Emperor, Jashwant came. Who came, beta? Jashwant. He paid more money and selling the same TV to Jashwant. Jashwant don't know about this sale. Even I am not the owner of the TV, he will get the ownership on the TV. See, seller must be in position of the goods in the capacity of the seller, and buyer purchase the goods in the good faith. Just for buying the goods in good faith. Buyer don't know about the this previous sale. Even I am not the owner, he is the owner. Even I am not the owner, he will get the ownership. Done. Clear? We discussed yesterday. Next, sale by the buyer in possession before transfer of ownership. Before transfer of SG giving the bag to Ganesh for 10 days. Goods on an approval basis. Goods and on Ganesh use the bag for 10 days. How many days? Select the bag, keep it. Otherwise, return it. On third day itself, is selling it to Arvind. Selling it to. On third day, even Ganesh is not having the ownership. He will get the ownership. Then, because goods on an approval basis, automatically on third day, ownership will transfer to SG to Ganesh, Ganesh to Arvind. Then, clear. Next, sale by the unpaid seller. So, I sold the goods, but you're not paying my money. Then, I already exercised the right to stop at the goods in transit. Still, you are not giving the money. I give a notice. I can sell. Even you are not the even you are the owner. I can resell. We discussed. Next, sale by the finder of lost goods. You lost your bag. I find the bag. Can I sell the bag? No, but I can sell the bag when if you are unable to found. You are found but refuse to pay the lawful charges. And goods are perishable in nature like milk, bread, flowers, food. Without your consent, can I sell? Yes. Last one. Searching expense exceeds two-thirds of the value of the article. So without your consent, I can sell. Even you are the owner, I can sell. You will get the ownership. Even I don't have the ownership. Last one. Sale by owner by estoppel. Estoppel. So which car is this? Audi car. Whose car? SG car. Whose car? SG. But before me, my friend Sahiti is selling to Rajani. Sahiti said to Rajani, Rajani, it's my car. I should stop here or not? I should stop. Whether I'm stopping? No, I'm laughing. Even Sahiti don't have the ownership. Rajani will get the ownership because it is a sale by estoppel. Last one. Sale by the pledge. Sale by the pledge. So, Sahiti is keeping her gold with me. SG. And taking 1 lakh rupees by keeping the ornament. By keeping the ornament. She said, I will pay the money next month first. Next month first. I will take back my article. 3 months is completed. Still, she is not paying the principal and interest. I said to Sahiti, if you don't make the payment, I will sell. I will. Still, she is not responding. Who is the owner of the necklace? Sahiti. Still, since she is not paying the money, no, but I am the pledging. I sold it after giving a notice. So Rajni purchased in the auction. Whether I am having the ownership? No. But Rajni will get the ownership. Then clear. Last one, sale by the official receiver. Official receiver. Sahiti become insolvent. Sahiti is having a car. Sahiti is having the car. Done. Car are yes sir, no sir. Who is the owner of the car? Sahiti. But she become insolvent. Hai. So court is appointing me as the official receiver. Sahiti become insolvent. Court is appointing me as the official receiver. My duty is to sell the car, auction the car. I am not the owner of the car. I auction the car. This car is purchased by Rajini. Purchased by the Rajini. Where even I am not the owner of the car, Rajini will get the ownership as per insolvency bankruptcy code. With this, we done with the concept of the transfer of property. Transfer of property. In the next class, we'll do the standard question bank. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Yeah, welcome back, sir. In the last class, we have completed performance of the contract of sale and delivery. Yes, hello, sir. We'll revise the performance of contract of sale and delivery. Rapid revision. So, what's the meaning of performance of contract of sale? Seller has to give the delivery of the goods to buyer. Seller has to deliver the goods to buyer. So how we have to do delivery being a seller as per agreed quantity, agreed quality, agreed manner, agreed place. The seller has to do the delivery. Seller has to do the buyer has to accept the delivery. Accept the delivery by paying the price at a agreed time, agreed place. First of all, what is the meaning of delivery? Delivery means voluntary transfer of the possession. Voluntary transfer of from seller to buyer. So we're giving the possession of the goods from seller to buyer. It is said to be delivery. It is said to be delivery of the physical possession is not always important because there is a delivery known as the constructive delivery. There is no change in the possession of the goods. What is the modes of delivery? By doing anything which parties agreed. Which parties to be treated as delivery. So few people said if you keep the rice bag before the shop delivery, few people said you have to keep in his hands only. That is deemed to be delivery. That can be anything which buyer and seller is agreeing. And by doing anything which has the effect of putting the goods into the buyer or his agent's possession, then it is deemed to be delivery. Next, types of delivery: star, star, superstar. Star, star, superstar. Star, star, mega star. Star, star, 5 star. Types of delivery. So, first one is the actual delivery. Which delivery? It is also said to be physical delivery. Physically handing over the goods from seller to buyer, like bottle, like remote, like pencil, like pen, soap, and a bit of actual delivery. Symbolic delivery. It is not a physical delivery. Physically, we will not give. Some symbol shows that delivery is deemed to be happen. Like instead of the car, can we lift the car? No, we give the car keys. Delivery is deemed to be happen. Constructive delivery, fictitious delivery, atonement. How many names are there? 3 names are there. Constructive, fictitious, atonement. What does it mean? There is no change in the possession of the goods, but delivery is deemed to be happen. For example, SG selling the goods to Rajani, but my goods are in the Sahiti warehouse. Sahiti warehouse. Then I sold to Sahiti. From next month, I will not pay the rent. I sold it to Rajani. Then Sahiti will make a call to Rajani. Rajani, I am holding your goods on your behalf. When third party informing to buyer that the third party is holding the goods on behalf of the buyer, delivery is deemed to be happen. There is no change in the possession. Earnestment is given towards the security. Advancement is given towards the price of the goods. The contract becomes void. It will be forfeited. It will be returned. It will be. This is towards the price of the good. This is not towards the price of the good. This is for the not to selling it to someone. నువ్వు వచ్చేంత వరకు ఎవరికి అమ్మకుండా పక్కన పెట్టినందుకు ఇచ్చే ప్రైజ్ ఏమంటాము ఎర్నెస్ట్ మనీ. దట్ మచ్ ఇంపార్టెంట్ ఆల్సో. నెక్స్ట్ రూల్స్ రిగార్డింగ్ ద డెలివరీ. సో వీ హవ్ నియర్లీ 10 to 11 rules are there. But summary of the 11 rules we'll read one by one. First one is the payment and delivery. Generally, if nothing is specified, payment and delivery will happen at the same time. If you go to bakery, we will give 40 rupees, he will give pastry. Both will happen at the same time. Concurrent means same time. Mode of delivery. Modes of delivery anta doing anything which parties are agreed by keeping the goods in the hands of the buyer. It can be physical, it can be symbolic, it can be effect of part delivery. Effect of part delivery, star, star, superstar. See here, what is the meaning of effect of part delivery? I said to Rajni to give delivery of the 100 bags of the rice. How many bags? But I am giving 40 bags only. Ownership also transferred for 40. It is said to be part delivery. Is deemed to be part delivery. I am giving the delivery of the 40 bags of the rice to Rajni, but ownership is transferred for the 100 bags. It is deemed to be part delivery. Is deemed to be whole delivery. Then here, if 60 bags are destroyed, who should bear the risk of loss of the good? Buyer. Here, 60 bags are destroyed, who should bear the risk of the loss? Seller. That question also very, very important. Buyer to apply for the delivery. Generally, seller will need not give the delivery of the goods unless buyer is asking for the delivery. So, buyer has to ask seller, sir, we paid the price, please give the delivery. Otherwise, seller is not need not give the delivery of the goods. Place of delivery. Next one is the place of delivery. If place of delivery is specified, Amir paid, we have to deliver the goods only at a specified place. Place is not specified. place is not specified. It is two types. In case of contract of sale, in case of agreement to sell. In case of contract of sale, place of delivery will be placed at which the goods are. Place at which goods are at the time of contract of sale. Contract of sale is entered in the Amirpet, but shop is in the Kukatpalli. Place of delivery will be Kukatpalli because goods are in the Kukatpalli. In case of agreement to sell, it is again two types. In case of the existing goods, in case of the future goods. In case of existing goods, agreement to sell, place of delivery will be the same place at which the goods are at the time of contract of sale. Then, in case of future goods, place of delivery will be place of manufacturing. Place of the factory in the Bongil. Delivery should be given at the Bongil. Next, time of delivery at the. If it is agreed on, agreed time. If it is not agreed on, within the reasonable time, we have to go delivery of the goods. Next, delivery when the goods are in the position of third party, it is nothing but a constructive delivery. Which delivery? Once third party informs the buyer, once third party informs the buyer that he is holding the goods on behalf of the buyer, the delivery is deemed to be happen. Seller, buyer, third party. Next, demand for delivery is treated as the ineffectual. It is the duty of the buyer to demand the delivery, but you have to ask only during the reasonable hours. You should not ask midnight 3 o'clock for delivery of the goods to the seller. If you are asking at 3 o'clock midnight, that is not a valid act, valid requesting the delivery of the goods. Expense of the delivery, who will bear? Seller, until goods put into deliverable state. Which state? If you purchase something, rice packet, rice 1 kg, whose cover? SG cover, seller cover. That rubber band, SG. Yes sir, no sir. Until goods put into deliverable state, seller will bear the risk of loss of the good. Next, delivery of the wrong quantity. Delivery of the three types: short delivery, excess delivery, mixed delivery. Short delivery. I said to give delivery of the 100 bags of the rice, but I'm giving only 80 bags. Short delivery. The buyer can reject the goods, buyer can accept. If you're accepting 80 bags, pay for the 80 bags. Excess delivery. I have to deliver 100 bags, but I'm delivering 120 bags. Buyer can reject the full and accept 100, reject the 20. He can also accept the 120. Then last one, mixed delivery. Which delivery? I said to give delivery of the 100 bags of Sona Masuri 1 year old. Sona Masuri 1 year old. But I'm giving 80 bags of Sona Masuri rice, 20 bags I'm giving the Hamsa or BPT, mixed delivery. So buyer can accept the goods as per the contractor, reject the rest. He can accept this one, reject the rest. He can also reject the whole. But I'm giving the Sona Masuri instead of 1 year old, 80 bags I'm giving 1 year old and 20 bags I'm giving a new rice. The contract is not deemed to be, the section is not deemed to be attracted. The section will not be attracted. There is no mixing of the goods. Mixture means different description, different and even in case of excess delivery, short delivery, buyer can reject the goods. Buyer can, but you can't cancel the contract. Again, seller has to give the right quantity. Buyer has to accept it. In case of the minor negligible variation, the contract will not be cancelled. I have to give the 1000 kgs. If I'm giving 1 kg less, there is not a short delivery. 1 kg more, that is not an excess delivery. Negligible variance may be there because of the loading and unloading. Next, delivery by installments. Generally, buyer need not accept delivery in installment. So you have to give the whole quantity in one time. You have to give everything in the one delivery, but not in installment. Next, delivery to carrier. Delivery to carrier. If goods are delivered to carrier, it is deemed that goods are given to buyer itself. Delivery to carrier is equal to delivery to buyer itself. However, so who has to enter into agreement with the carrier? Seller. Seller has to enter into agreement with the carrier, but buyer may pay the price. If goods are shipped through sea, I have to inform the buyer. Buyer, please take the insurance policy. Please take the. But it is a duty of the buyer to take the insurance. If I don't inform, I will be liable. I have informed them, but buyer is not taking insurance. I will not be responsible. Then seller duty is to inform. Buyer duty is to take the insurance. Last concept of acceptance of delivery, very, very important. Star, star, superstar. Delivery is not equal to acceptance of delivery. Delivery doesn't amount to acceptance. It is something more than the mere receipt of the goods. It is the final assent given by the buyer to the seller. It can be three times. So he made a call to me. Srinath sir, goods are delivered. It's fine. Express acceptance. Second one. So he's opening the rice bag. He's using the rice bag. He does any activity which shows that he is accepting the goods. Delivery is deemed to be happen. Implied acceptance. He's not informing, but he's using it. What does it mean? He's accepting. Third one. I delivered the goods to the buyer. He's not rejecting. He's keeping with himself. Whether he's rejecting, no. Whether he's using, no. Whether he's keeping with himself, yes. Returns the goods beyond the reasonable time. It is also deemed to be acceptance because if you don't like, you have to inform, no. Last concept of duties of the buyer. Duties of the buyer when there is a delivery of the goods. Seller is delivering the goods to buyer. Buyer don't like. He want to refuse. He want to refuse the goods. What is his duty? Inform the seller, Babu seller, I don't want the goods. Please take back your goods because it is not as per the contract. And last point, seller is ready to deliver the goods, but buyer is not taking the delivery on time. Still, goods are delivered at 10 o'clock to the shop, but shop is closed. Shop is opened at 12 o'clock. Because of this, the auto person charging 200 rupees extra waiting charges. Who has to pay? Buyer. And since you are not coming on time, seller is waiting. है ना? And he's taking care of the goods because rain came. Na, beta? He's trying to purchase the cover to save the goods. He was spending 500 rupees. Who? Seller. You have to pay for the buyer. Seller or not? Who's duty? Buyer. So seller is ready to deliver the goods. Buyer is not accepting. Buyer is liable to pay to seller. Two things. Loss caused due to negligence. That is 200 rupees waiting charges. Auto waiting charges. B. Reasonable charge of the care and custody. That is, we purchase a cover to secure the goods. That is 300. 500 should paid by buyer to seller. With this, we are done with the concept called the performance. So remaining part we'll discuss in the next class. In the next class, we'll do the scanner. Have a great time. Enjoy the day. Prepare well. Is the signing off. Take care. Welcome back, sir. Let us revise the concept of unpaid seller. A seller. So what is unpaid seller? What is so who is the unpaid seller? Seller is said to be unpaid seller if seller price is not paid. Seller's price is unpaid seller is the seller whose money is not paid by the buyer. In general meaning, when you see the definition of the unpaid seller, seller is said to be unpaid seller when whole of the price is not paid. Which price? Whole of the price is not paid. Actually, the goods is worth of 1 lakh. How much? Buyer paid 99,000, but 1,000 is pending. Whether I am unpaid seller? Yes. When the whole of the price is not paid attendant. When a bills of exchange or any other negotiable instrument has been given as a conditional payment, which payment? Which is dishonored. Actually, buyer purchasing the goods and buyer is giving a check. Check is dishonored. Check is seller is said to be unpaid seller. Said to be is giving a conditional payment. What is conditional payment? Check. Check is dishonored as said to be unpaid seller. And seller includes the seller and its agent also. The seller may be the himself or seller may be his agent also. For example, Tata Motors sold the goods. Who? Tata Motors. So who's the seller? Tata Motors. So who are the agents of the Tata Motors? Directors are the agents. Next, when a seller is not said to be unpaid seller, when the goods are sold on the credit, no, seller is not said to be unpaid seller during the credit period. During the goods are sold on credit and credit period is not expired. Seller is not said to be unpaid seller. Seller will become unpaid seller if buyer become insolvent during the credit period or credit period is expired. See, actually I sold the goods on 1/1/27. Credit period is 3 months, 31st March 27. During this period, I am not an unpaid seller. If money is not paid on the expired credit period, I said to be unpaid seller from 1st April. First term, clear na? So seller is goods sold in creditor. Seller is not an unpaid seller during the credit period. Credit period is not expired. Credit period is here. I am not an unpaid seller. Here I am not an Seller is an unpaid seller when buyer becomes insolvent during the credit period. For example, goods are sold on 1st January till the 31st March, credit is given, but on 10th March, buyer become insolvent. Buyer become, from the date of insolvency, I said to be unpaid seller. And goods are sold on the creditor, credit period is expired. What is credit period of 31st March? Then on 31st March, buyer is not making the payment, I said to be unpaid seller. If full price has been tendered by the buyer, full price is tendered by the buyer, seller is not accepting. Actually, buyer gave the money, but seller is not accepting. I am not an unpaid seller because that is not buyer fault. Seller who has received the price of the goods but not for the other expenses. Price of the goods is 10,000. It is paid. And loading and unloading charges, transportation charges 1,000. It is not paid. And not said to be unpaid seller. Not said to be. Then it is only for the goods, not for the other expenses. Next, we discussed rights of unpaid seller against the goods and against the buyer. 10 stars, 5 stars, 5 stars. So, goods of unpaid seller, rights of unpaid seller. Unpaid seller has the 3 rights on the goods: right of lien, right to stoppage of goods in transit, right of resale. And against the buyer, so we can sue for the price, sue for the damages, sue for the cancellation of the contract, sue for the interest, sue for the एक देखेंगे बेटा. And rights of the buyer on unpaid seller. For example, he may be seller or unpaid seller. I am selling the goods to Rajni, but I am not giving the goods to Rajni. Whose fault? Seller fault. Rights of buyer. Buyer can sue for the damages, sue for the specific performance, sue for the breach of warranty, sue for the cancellation of the contract, sue for the interest, sue for the. Then next, first, rights of unpaid seller on the goods. First one, right of lien. Right of, important sir. Lien means right to retain the possession of the goods. Right to retain the until full price is paid. Until full price is paid. Until you pay the money, I will not give the goods. उसको बोलते हैं lien. Then lien means right to retain the possession of the goods until price is paid. I sold the goods to Rajni. I sold this remote to Rajni. She is not paying my money. I said I will not give the remote unless you pay the price. That's the right of lien. Meaning of the lien, when it can be exercised, how it can be exercised, and when it is lost. When it can be exercised. Lien can be exercised if goods are sold without any credits. I am not giving any credit to Rajni. Rajni is not giving me money. I can exercise lien on this remote. And goods are sold on creditor. Credit period is expired. Actually, I sold the goods to Rajni on 3 months credit. 3 months is expired, but she is not paying my money, and the good is in my hand. I can exercise right of lien. And if buyer become insolvent, impliedly he is saying I don't have any money. I can exercise the right of lien. And how it can be exercised? By retaining the possession of the goods. So I will not give the remote unless you pay my price. Second one, when part delivery is treated as the part delivery, we can exercise lien on the remaining. Actually, I sold 100 bags. How many bags? Of rice to Rajni. How many bags I sold? 100. 60 bags are delivered. 40 bags is with me. I can exercise lien only on the 40 bags which are in my warehouse. And where the right of lien extends to whole of the goods. Which goods? If 100 bags are in my position only, I can exercise lien on the 100 bags. 60 are given. I can exercise lien only on the 40. 100 bags are in my position only. Then I can exercise lien on the 100 bags. Then this point is important, beta. D point. Seller can exercise right of lien even if he obtain the decree. Decree means court judgment. Decree means court order, court judgment. So I sold the rice bags to Rajni. She is not paying my money. I went to court of law. Court gave the order to Rajni. Rajni, please make the payment to SG within 5 days. Within how many days, sir? Then I said, I will not give the position of the good. Rajni said, yes, sir, I am not paying the money. We went to court of law. You obtained decree also. Then why will you exercise right of lien? I have both the rights. I can exercise right of lien. I can also exercise the right to go to court of law to obtain decree. That is different. This is different. Next, seller may exercise the right of lien even though he possesses the goods as an agent. Actually, I sold the goods to Rajni TV and delivery bhi de diya. I sold the goods to Rajni. I give the TV to Rajni also. She's not paying my money. Can I have any right? No, because goods are not with me. But something must happen to that goods. They're damaged because her kids are playing in the home. Then she's bringing back to my showroom with TV. She's coming back to my showroom with the TV for the repair, for the bail or bailing. Now I'm holding the goods as a bailee. Can I exercise right of lien? Yes. TV 1 lakh to repay 20. I can retain the TV for the 120. Done. So we know meaning of the lien, when it can be exercised, how it can be exercised, and termination of the lien. When it will be lost. When right of lien will be lost. Goods are delivered to carrier. Delivered to whom, beta? Auto. Goods are delivered to carrier. Lien will be lost. Buyer lawfully obtain the delivery. So goods are given to buyer's agent. Buyer's agent. Goods are given to buyer. So goods are taken by the buyer or buyer's carrier. Carrier means lorry, auto, DCM. So if seller is waiving the right of lien, I said to Rajni, even you don't give money, I will not exercise right of lien. I will not exercise the lien will be lost. When subsale is made by the buyer with the consent of the seller, actually I sold 100 bags to Rajni. Then Rajni said, Srinivas, can I sell 20 bags to Sahiti? I said yes. Then I realized Rajni will not make the payment. In my shop, how many bags are there? 100. Belongs to Rajni. But out of this 100 bags, 20 bags sold by Rajni to Sahiti with my consent. I can access lien only on the 80 bags. Then last one, if seller leads the third party to believe that he has no right of lien, nothing but waiver. Express waiver or the implied waiver, right of lien will be lost. When right of lien is lost, that is goods are given to carrier. So when right of lien is lost, we will get the yeah. So when right of lien is lost, unpaid seller will get the second that right to stoppage of goods in transit. So we discussed about the right to stoppage of goods in transit. We are starting the lorry from Hyderabad. Seller is in Hyderabad, buyer is in the Vizag. It will take totally 12 hours journey. If you are starting in the morning 6 o'clock, we will reach there by evening 6 o'clock. Average 12 hours journey. Hyderabad to Vijayawada 6 hours, Vijayawada to Vizag 6 hours average. Yes or no, sir? To exercise this right, goods must have left from the seller, not reached buyer. Good must be in transit. That means goods must be in where left from seller, not reached buyer. Goods must be in transit, and buyer become insolvent. Buyer become. This right can be exercised if the five conditions are satisfied. Goods left from seller, not reached buyer. Goods must be in transit. Seller is unpaid. Buyer become. That is said to be. Then we can exercise right to stop the goods in transit. What does it mean? Seller has the right to stop the further transit of the goods, stop the vehicle in between with a view to obtaining the actual position of the goods. So we can stop the goods when they're in the middle of the transportation, stop the vehicle, bring back the goods. So when the goods are in Vijayawada, goods are in, my friend made a call from Vizag. He said, Srinivas sir, to whom you sold the goods? I said, I sold the goods to Gopal. Then Satish, my friend, is asking, sir, whether he paid the price. I said, no. Then why you are giving the goods? I said, he's sending the money through lorry. Through. Satish said, Srinivas sir, you are innocent. Listen. एक बार चले गया goods, आपका पैसा नहीं मिलता. I'm asking why. I'm asking why. Then my friend said, buyer becomes insolvent. बर्बाद हो गया. किधर गया? So he will not make the payment. Then I said, Babu, Satish, stop the call. I have to make a call to driver. Who's the driver? I made a call to driver. Babu, driver, where are you? I'm in Vizag. I'm in Vijayawada. Do one thing. What are you doing? Having the double egg fried rice. Where is the daba? Good ఎక్కువ rice తక్కువ. సార్ నో సార్ బాగుంటుంది అలా ట్రై చేయండి వెళ్ళినప్పుడు. డోంట్ టెల్ మై నేమ్, దే విల్ నాట్ గివ్ ఎనీ డిస్కౌంట్. ఓకే ఆరా Navadip, do one thing after having your lunch. Take U-turn. Take, don't go to Vizag. Get, bring back. Come back to Hyderabad. Yes sir, no sir. Duration of the transit. Duration of transit means goods left from the seller not reached buyer in between set to be transit. And termination of right to stoppage of goods in transit. When this rate will comes to an end. This rate will comes to an end once transit ends. Once transit ends, this rate also comes to an end. When transit comes to an end, transit comes to an end when buyer obtains delivery at the destination. At the goods reaching the Vizag, reaching the in the Vizag, buyer taking the delivery of the goods. This rate will be lost because this rate can be exercised left from seller, not reached buyer obtains delivery before destination. So buyer said, Gopal said, Srinath sir, where is the goods right now? I said, after 12 o'clock, it is in the Vijayawada. Buyer said, Srinath sir, do one thing. My lorry also in Vijayawada, it is also empty. Do one thing. Unload the goods from your lorry, load it in the my lorry. This was happened at 12 o'clock, 12:30 at Vijayawada. 1 o'clock I came to know that buyer become insolvent. Can I exercise this right? No, because transit is ending at Vijayawada before the destination. If carrier holding the goods on behalf of the buyer, carrier holding the goods on behalf of the buyer. See, after lorry reaching the Vizag, buyer made a call, driver made a call to buyer. Sir, from now I'm acting after reaching the lorry at RK beach. Driver made a call to buyer. From this point of time, I'm acting as your agent. Whose agent? Transit comes to an end. Then when part delivery is deemed to be delivery of the whole, so we cannot have the right of we cannot have the right to stop at the goods in transit because goods are deemed to be delivered. When subsale is made by the buyer with the consent of the seller, when the lorry is in Vijayawada with 100 bags of the rice, buyer selling the 20 bags to customer with the consent of the seller, with the consent of the at 10 o'clock. At 10 o'clock. 12 o'clock I came to know that he become insolvent. Can I exercise this rate? Yes, only on 80 bags, but not on the 100 bags. Next up, where the goods are delivered to ship, started by the buyer, nothing but third one only. It may be carrier, it may be ship also. Then, next, how carrier may be acting. Here, carrier means that lorry, the DCM. He may act in three capabilities, three capacities. Lock the door. See, if carrier is acting as an independent person, we can exercise right to stoppage of goods in transit. If carrier is acting as the agent of the seller, directly I can exercise the right of lane. Right of because goods may be in my warehouse or it may be in my vehicle also. If carrier is acting as the agent of the seller, agent of the so we cannot exercise the right of lane, we cannot exercise the right to stoppage of goods in transit also because goods delivered to buyer because it's acting as the agent of the buyer. Then how stoppage in transit may be affected? I can go with a Hayabusa bike, sports bike. I can stop the lorry. I can bring the lorry. Otherwise, I can make a call to driver. Babu driver, where are you? I'm in Vijayawada, sir. Stop the vehicle. Come back with the vehicle. With the stop the vehicle. Bike like వచ్చేస్తాడు ముందే నవదీప్ గారు మీరు ఏం చెప్పారు సార్ స్టాప్ ద వెహికల్ స్టాప్ చేస్తున్నా కమ్ బ్యాక్ అంటే కమ్ బ్యాక్ వచ్చిన విత్ వెహికల్ అండ్ గూడ్స్ విత్ వెహికల్ అన్నారు కదా సార్ బస్సులు ఇక్కడ పడేసి వచ్చినా అంటున్నాడు అమ్మో Yes, sir, no, sir. So, unpaid seller can take the possession of the goods, or unpaid seller can give the notice to carrier. So, this is how we can exercise this right. Then, duty of the carrier. Duty of the carrier. It is a duty of the driver to bring back the goods as per the instructions of the seller, as per the directions of the seller. Next, effect of subsale or pledge made by the buyer. Effect of subsale or pledge made by the buyer, not that much important. I sold the cycle to whom, beta? Navadip. But Navadip is not paid my money. Navadip said, sir, let me go for trial run. Aaron, trial got assignment at a weekend. Ashwanta Navadip on that. So I sold the cycle to whom, beta? Navadip. Cycle is given, but my money is not paid. Then Navadip went to Gopal. He's taking 15,000 rupees. How much? Out of this 15,000 rupees, for 10,000 he's keeping the gold ring. For 5,000 rupees is keeping the cycle. Done na? So I can request the Gopal, when Navadip make the part payment like 6,000 or 7,000, first release the cycle. So I can exercise the some right on that cycle. Then next, this one is important, but right of inverse, right to stop at the goods in transit, easy. Right of resell. Next one is right of. See, right of resell means it is the right of the unpaid seller to resell the goods. Resell if buyer commits the default. Buyer commits the. It means right of unpaid seller to resell the goods if buyer makes the default. Buyer makes the rights of unpaid seller. So unpaid seller can resell the goods in three cases. If the goods are perishable in nature, like vegetables, milk, you're not paying my money. If I keep the goods, so perish hota, I can resell. And notice is given, but buyer did not make the payment. I give a notice to buyer, buyer, please make the payment by 10th of this month. Otherwise, I will resell. I give a notice, still you're not responding, I can resell. Seller expresses reserved right of resale. When I am selling the goods, in the invoice, I kept a condition. Babu, Balraj, Nagaraj, Kaltraj, buyer. If you don't make my payment, if you don't make my, I can resell your goods. I can resell your, if I have the possession. If I have the, I can resell the goods. But we have to resell after giving the notice. After giving the, actually, the goods is 10,000. How much better? I gave a notice also better. Please make the payment. He is not making the payment. I resold for 12,000 rupees. How much better? Profit on resale. I can retain. Seller can retain. Actually, he has to pay 10,000. Since and he's not giving, I gave a notice also. Still, he is not paying. I sold it for 7,000. How much loss? 3,000. Seller can recover it from the buyer because I am getting loss because of you. Moreover, I give a notice also. If I am reselling the goods without giving a notice, without giving a, if profit is there, no, give it to buyer because your goods I am selling. I am not supposed to. We have to give it to buyer. If there is any loss, no, but seller has to bear that loss. Unpaid seller has to bear that loss because we are not giving the notice. Next, we discuss the rights of buyer. Rights against the buyer. What we can do the goods, but if he's not paying the money, being unpaid seller, we can sue for the lien. We can sue for the stoppage of goods. We can sue for the resale. What I can do the buyer if buyer doesn't make the payment? Sue for the price. Sue for the damage. Sue for the reputation of contract. Sue for the interest on the price. You have to pay 1 lakh rupees. You're not paying me 1 lakh rupees because of that. I'm losing the interest on that 1 lakh for 3 months. Then now, so we can sue for the price of the goods. We can sue for the interest. We can sue for the damages. We can sue for the cancellation of the contract. I sold the goods to Rajini. Rajini paid the money, but I'm not giving the goods. Whose fault? Seller fault. I sold the goods. I got the ownership. She gave the money. Yes or no, sir? Ownership is transferred, payment is done, but I am not giving the delivery of the goods to buyer. So what buyer can do? He can sue for the non-delivery, damages for the non-delivery, sue for the specific performance. I want that rice bag only. He can sue for the breach of warranty, sue for the reputation of the contract, and sue for the interest. Then last concept of auction, very important from exam point of view. Auction sale. Yes, sir? It's a public sale. Which sale, beta? It's a public sale. Intending buyers can come and participate. We discuss one example, beta. Auction of the Ganesh Laddu. Which Laddu? So after performing puja for 11 days, how many days? 11 days. Today is Nimarjan. So we're going for auction. It's an invitation to offer. Public sale basically. It's a public sale. It's a auction or this is a invitation to offer. So many people came to participate in the auction. So we said the laddu will be 1,116 rupees. 1,116 minimum price offered by auctioneer. It is said to be the upset price. A price? Reserve price. A price? Minimum price. Then Gopal said 2,000, he said 5,000, he said 10,000, he said 20,000, he said 50,000, and she said 1 lakh rupees. And these people are said to be bidders. The prices offered by these people are said to be bids. So The auction is completed by shouting going, going, gone, or 1, 2, 3, or hammer number 1, hammer number 2, hammer number 3. Before saying 3, can Gautami revoke her 1 lakh rupees offer? Yes. Before saying 1 lakh, before saying 3, can I say I don't want to sell the laddu to highest bidder? Yes. Because offer need not be accepted. Offer need not be. She said 1 lakh, I don't like that price. I need not sell. Moreover, offer can be revoked before it is accepted. Generally, auctioneer should not participate in the auction, but auctioneer can participate in the auction with the consent of the participant by appointing one agent. He said to be by bidder, decoder, white bonnet, or puffer. 4 names are there. We can appoint only one puffer to participate on behalf of the auctioneer. If 2 laddus are there, but it's said to be auction in lots. Each laddu is deemed to be separate auction. Separate auction. And for example, if we are appointing a agent just to increase in the price, it is said to be pretended bid. It is said to be the pretended bidding and whatever the option of the buyer. And if there is any agreement between the 2 bidders not to bid against each other, Gopal said to Satish, Satish, if I make a bid, no, don't give the counter bid, don't make the counter bid. It is said to be knockout agreements, it is valid. So I will bid for the 1 lakh rupees, you give me 50,000 rupees, I will give you half laddu. So please don't increase the price because you want laddu, I want laddu. Let the auction should not be benefited. Then next, damping. If there is any agreement between the bidders not to participate in the bid at all, Gopal said to everyone, no one should come to bidding so that he can take it for the less price. That is said to be damping, that is unlawful. So it is a public sale, public sale, intending buyer offer the prices at which they are ready to buy. So if I am appointing any person to auction on my behalf, he is said to be agent, I am said to be principal. It is governed by law of agency. Next, participants are said to be bidders. So the person making the offer price known as the bidder. Person making the bid is said to be the bidder. Auction may auction his goods on his own. He can appoint the agent also. Advertisement is an invitation to offer. Intending buyers have no right to sue the auctioneer if the auction is cancelled because I did not sell it to highest bidder. It's an invitation to offer. So auctioneer can refuse to accept the highest bid also because offer need not be always accepted. If 2 laddus are there, but they said to be auction in lots, each laddu is said to be a separate auction. We can accept the offer by fall of hammer 1, hammer 2, hammer 3, shouting 1, 2, 3, or going, going and gone. Next, minimum price is said to be the upset price or the reserve price. So until completion of the bidder may withdraw his bid also because offer can be revoked before it is accepted. So auction can also participate by appointing the one agent. He is said to be puffer, by bidder, white bonnet or the decoder. If you are not following the rules of the auction, it is said to be the fraudulent auction. And if we are appointing any person just to increase in the price, it is said to be voidable with the option of the buyer. Knockout agreements we discussed, damping also we discussed, and last concept, inclusion of increased or decreased taxes in the contract of sale. See, after completion of the auction, we sold the goods for the 1 lakh in the auction. Subsequently, due to some taxes like GST, service tax, VAT, excess, customs, so government is imposing some tax. Who's taking this money? Government or auctioneer? Government. So who should pay this extra money? Who should bear that? Seller or buyer? Buyer has to bear the taxes. Done. So with this, we have done with the last topic called unpaid seller. In the next class, we'll do the channel. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care.